Hello, I'm Brad Green, and I'm one of the attorneys at King and Green. And I'm sitting in our conference room here shortly after doing the execution of a will today for some clients. So I wanted to talk to you a little bit about the importance of having a will. Most people understand that it is better to set out your wishes for what happens to your assets after you pass away in writing. And it's better to do that because you don't want any disagreements or questions about who you wanted to get what you have when you pass away. Most people, though, are a little bit confused as to how easy it is to effect a valid will. And I'm going to be talking, of course, about Alabama law. I'm not going to be talking about the rules that apply in any other state. But wherever you live, if you go to see an attorney to draft your will should stand up no matter where you go. But obviously, if you have and live in Louisiana, you probably want to consult a Louisiana lawyer about Louisiana property. If you live in Alabama, you want to consult an Alabama lawyer about property and estate law in Alabama. Now, drafting a will in Alabama is very simple, but one thing that we see all too often is people that in an attempt to save a few dollars will use an online do-it-yourself type program or something that they can buy at an office supply store like Office Depot or Office Max. And unfortunately, what we see from time to time is when someone passes away and they have drafted a will without the benefit of a lawyer advising them and drafting it for them, that those documents sometimes do not stand up in court, or sometimes they do stand up, but they don't do what the deceased wanted to accomplish. There's been a recent case in this area where someone, in fact, did download a do-it-yourself will form from the internet and filled it out, and they passed away, and the will was admitted to probate, but it was missing one of the most basic parts of any will in Alabama. But because it was missing that part of what they wanted to accomplish did happen, but a big part of it was not able to happen, because if you don't have a will, or if your will doesn't address all the things that it needs to address, there is a statute in Alabama that tells us how a deceased person's property will be divided after their death if there's no will. That's known as the intestate statute. So if you don't have a will, certainly the intestate statute will govern. Now, not everyone who has a will have to have their estate probated in court. That's important to remember, because again, a lot of people want to stay out of court if possible, and after they pass away, they don't want their family members or their heirs to have to go to court. And I want to make it perfectly clear that just because you have a will does not mean your estate will have to be probated. Proper estate planning sometimes can result in no one having to go to court, a will not even being filed with the court after a person's death if there's proper estate planning. However, I think it's very important, if you have loved ones or you have individuals or entities or charities that you want to receive money or assets after you pass away, if it's that important to you, then it is worth the investment to talking to an attorney who can advise you about how to accomplish that. A properly drafted and executed will in Alabama can protect your estate from having to pay unnecessary costs. It can save on attorney's fees in the future if your estate has to be probated. It can save administrative costs on the person that's going to be acting as your personal representative, also sometimes called an executor or executrix if it's a woman. It can save them a lot of money. It can preserve more of your assets to go to the people you want them to go to. And so sometimes by saving maybe $100 by downloading a form from online, you can end up costing those that you wanted to receive assets thousands and thousands of dollars. And unfortunately, we see that sometimes when people pass away and their heirs bring us a will, and we realize that the will is deficient in some way. In Alabama, an attorney can draft a will for you, and it can be notarized and signed by two witnesses of the person making the will. Has to have a notary and two witnesses, and the will will be considered self-proving. And if it does have to be probated in the court, that will speed the process along, and it's going to be typed up, obviously, and executed and properly witnessed and notarized, and the court generally will have no qualms about issuing the letters testamentary. And that's what the documents are called that give the person that's the personal representative, or again, as I said, executor or executrix are interchangeable terms for the same position, the authority to do what they need to do to marshal the assets of the deceased and to get them to the people that the will says they're to go to. People or entities. You can obviously leave things to your church, to a charity, to organizations, not just to individuals. So those are some things about wills that I would keep in mind. It is important to get advice from an attorney that handles that kind of stuff. And if you have any questions about a will you have that maybe need to be updated, or you've never created a will and want to talk about having one, please feel free to give us a call at 205-937-3687. We'd be happy to talk to you about how we can help. Thanks.